Upon notice to the opposite party, my lord, extension of interim order. It's going to
Extension of interim order, please hand over the slip.
great.
I am praying for construction on 12 because my lord, the respondent police authority had started construction on my plot of land, though the without having any acquisition, though the land itself is Sally, my lord.
All right.
My lord, open.
Granted.
My lord, upon notice. बोलें
Subject to kindly as mentioning urgent motion. I filed this. But
You have filed?
Yes, I filed.
Yes.
But here there is a short-term mining lease. There was a
So
suspicion.
it's not appearing under the heading
Not
motion.
appearing. No,
When have you filed?
this was supposed to appear on 6th.
It has not appeared. Please
No.
hand over the slip. Mentioning the date of appearance in the list in the presentation form.
Given down the urgency, I'll just mentioning.
Please mention when it was expected to be.
My lord, upon notice, my lord, this is an application. My lord, we are praying for non-prosecution of a matter, my lord, upon
To
notice.
mention.
And another matter, my lord, under heading 4 orders, my lord, praying for
Why
inclusion.
4 orders?
My lord, it was lastly heard by Honorable Justice Aniruddha Rai, my lord. And there
4 orders, it has to be hard afresh. Please wait. Yes.
Not for correction.
For correction.
New motion.
New motion. When have you filed?
Lordship, this is 2025. It is 2024.
2024.
Yes, Your Lordship.
It did not appear.
Oh, Your Lordship.
Motion stage.
Yes.
Hand over the slip.
My lord, new motion matter. New motion
Yes,
matter
Mr. Bhattacharya.
2025.
Motion. Motion.
My
Please hand over the
motions
slip.
for inclusion, my lord.
Motion.
Motion.
It has been fixed on 13th.
Motion for inclusion.
13th. Please indicate that in the mentioning slip.
My lord,
Stand over the-
for inclusion in the list.
Yes, please hand over the slip. Motion.
My lord,
Motion.
new motion.
Lordship, on 20.
New motion.
For the Honorable Party Service then was the matter under the heading of mixed motion, Lordship. But the matter,
At the heading of
the matter is related to tender matter, Lordship. The private respondent wishes without following the terms and conditions, they have
tender matter group 1.
tender matter, Lordship. That means, Lordship.
Hand over the slip.
Then the urgency, Lordship, without following the terms and conditions, they have filed the documentation.
Please indicate the urgency in the list. Hand over the slip. Please indicate the urgency in the list. Hand over the slip.
My lord, may I please?
Restoration application, my lord. Restoration application.
Restoration. When it was dismissed for default, Mr. Banerjee?
My lord, earlier occasion, your lord heard this matter, my lord.
I heard this matter.
Thereafter, my lord, you also directly to file affidavit in opposition. They have not filed.
It's a hearing matter.
No, my lord. Restoration application.
Affidavit in opposition, it's a hearing matter, Mr. Banerjee.
My lord, restoration application, my lord. I know, my lord.
When it
Restoration
was-
application.
when it was dismissed for default?
2023.
23. Please wait for
My lord, your lord, it was already in the list in code number 7, my lord. You lord, you heard this
2023?
matter, my lord.
You could wait for 2 years. Please wait for some
And
time.
another, my lord,
Lord,
review application, my lord. Review application, second appeal.
Review second appeal. Second appeal, I have not heard any
Yes,
matter.
your lord, review any.
That was only those which has been assigned. I do not have the regular determination of
review, my
second.
lord, that is mentioned is there, my lord.
Second appeal, only some matters have been assigned, some old matters, only those matters. I do not have any.
My lord, mentioning
No,
for
second appeal
inclusion in
is-
list.
My lord, I am praying for mention in the inclusion list, my lord.
Yes.
My lord, one matter has been fixed on 7th of this month.
have
But
the-
my lord, unfortunately not appear in the list. I am praying for mention. For
Ask your junior to hand over the
Hello.
slip.
my lord, during this time, I have had no further.
Mentioning
Wait
for
your lord.
inclusion in list for
What
under
heading?
new motion.
New motion, please hand over the slip.
No matter for upgradation, it's appearing
Accreditation, it is appearing where?
item number 86 of the monthly list, my lord. Is
Item number 86.
yes, my lord.
Madam, please wait for 1 or 2 days.
That's contempt application, my lord. Order has been passed.
Contempt application.
Yes,
My order.
Yes, my lord.
All right. Please wait for 1 or 2 days.
My lord,
Yes.
senior citizen matter, my lord. Order has been passed from in 2024
Madam,
February.
please wait. This is the first day. Please wait for 1 or 2 days. Let me
But
see how
I'm-
far I can proceed.
Begging pardon, my lord, this is kindly recollect. This is the review application which was heard by your lordship and the Honorable Justice Supratim Bhattacharya, my lord. Advocate General was assisting your lordship, my lord. There is some urgency, my lord.
All right,
I can
hand over the
understand the
Yes.
Lordship, may I have your kind leave to mention a matter for non-prosecution?
Non-prosecution, please hand over the slip. to be mentioned.
Contempt application.
Land has been utilized in the year 1970.
Please,
My lord, then after they have preferred an appeal.
all right, please wait for this week. Please, let me see how far not today. Yes,
Lordship, this is a specially assigned matter. This is a second appeal pending from 2005.
it has been assigned.
Yes, Lordship, this is a specially assigned matter. So, Lordship, we had filed an application for occupational charges that got rejected. We filed one SLP.
It has been assigned, that's it.
Lordship, this is a specially assigned to your Lordship. This is specially assigned to your Lordship.
Oh, in that bunch.
Yes, Lordship. So,
Which item in the monthly list?
no, Lordship, this is coming for the first time.
All right, hand over.
There is an order of the Supreme Court, Lordship, to complete the hearing of second appeal within 3 months.
Show me the order. Who is for the, you are for the appellant or the respondent?
Lordship, I am for the respondent.
Who is for the appellant?
Lordship, I have just sent them a mentioning notice also. Miss Debanita Pal is appearing. I will again put them on notice if your Lordship directs me.
Please inform them. কালকে এটা কি আমাদের অ্যাসাইনমেন্টের মধ্যে আছে?
Lordship, I'm led by Mr.
দেখে নিন অ্যাসাইন ম্যাটারের মধ্যে থাকলে কালকে টু মেনশনটা দিয়ে দিন।
Lordship, just one
Tomorrow to be
request.
mentioned, madam.
Lordship, one request. I'm led by Mr. Menab Bose in this matter.
Madam, you have informed the order just today. It will appear tomorrow. You have to make alternative arrangement. You have shown me you have obtained an order of the Honorable Supreme Court, so I have to go by that. It's your choice. Who will argue? That's according to you.
My lord.
Have your permission to mention a matter?
Under what heading?
It's under motion.
Motion hand over the slip. It has not been taken up once.
On the last occasion, it was on 9 November 2025. Justice Partha Sharathi Sen have passed order to the matter that the matter should be appeared on the month.
9th November 2025.
Yes,
9th November, today is 10. 9th November was yesterday.
September, sorry.
Say so.
9 September 2025, Justice Honorable Justice Partha Sharathi Sen have passed the order to appear this matter on the monthly list.
Monthly list.
Lordship, kindly speak this matter, Lordship, as a matter is very important as it's a.
I have to go by the direction. Direction is in the monthly list, sir. Please hand over the slip.
One matter. Both these matter appear in the list of the
It's not appearing. Hearing or motion?
one motion, one application.
Hand over the slip. They can. Then why it is appearing? Then why it is appearing? Mr. Pan, ask your advocate on record to give a full-scale paper. Nowadays, in the list it has been mentioned. ওটা দেখে নিলে ওটা old contempt matter.
My lord, contempt matter, my lord.
File lying in contempt of my order.
The old contempt matter. Your lordship is taking the
Old contempt matter.
Yeah.
All right.
My matter is 2009. My lord, also contempt matter, contempt, 2010 too. Review act.
Review.
Some urgency, my lord, have been waiting for some time. Your lordship's order.
Hand over the slip. Yes.
Motion, my lord.
Please speak loudly.
Motion, my lord. Motion, listed motion.
Sir, she is mentioning, yes.
Your Lordship, may I be permitted to mention a matter under the heading new motion?
Hand over the slip.
May I?
May I permit to mention on matter, my lord, the motion of 2024.
Motion, yes.
Motion, my lord. Listed motion.
Motion.
Lordship, may I permit you to, this is a restoration application.
When it was dismissed for default,
Lordship, it's like, I have.
please ascertain the date, then mention.
Voting matter, it's the motion matter. Kindly.
2020 motion, 2014. Now it has become hearing.
Matter has taken up another bench, Lordship.
Please wait, madam. Please wait. Please wait for 1 week. Yes, call the list.
I am for the petitioner.
Yes.
My lord, the writ petition is preferred.
Who is for the state?
I am for the private respondent.
Who is for the state? Yes, Mr. Dey. No one is appearing for the state. First day, not the first day, maybe for this bench, but not the first day. Court reopened on 24th.
My service is completed. The affidavit of service is under affirmation, my lord. I have the photocopy.
Can you appear, Mr. Dey, in this matter? Yes. What is your, what do you want?
Very short point, my lord. The private respondent have constructed one hydraulic powered mini deep tube well without any valid sanction plan, my lord. They have not taken any sanction plan from the authority.
Which authority has to grant sanction?
My lord, the respondent number 2 and 3, my lord. This is the district level authority under the West Bengal Groundwater Resources Management and Control Act 2005.
Yes.
Submersive pump. I mean,
Please use the microphone.
submersive.
Please adjust it. Yes.
Sorry. Submersive pump, my lord, in my land, agricultural land, the collective connection and my lord,
You
water.
have to take permission.
No, that is not a my lord permanent construction. This is just only submersive pump that can be removed. And in my land, my lord, that not even
Whether permission is necessary or not, I am asking.
my lord, for submersive pump, agricultural land for that is
Yes, Mr. Dey. What do you say?
that is also my lord, in my land, not their allegation is in their land.
Yes. What is your response to section 7?
So 7, my lord. Copy of 6.
Yes, Mr. Dey. What do you say?
It will be considered by the authority.
Their prayer is also there, my lord. Number 2, my lord, will be the best authority.
That will serve your purpose.
No,
Consideration.
my lord, absolutely. That is the prayer, my lord, to consider. That is in the prayer. Prayer number C. For demolition. Without hearing, my lord, demolition.
The order to consider, and if that is in violation of the section,
Absolutely, my lord.
then my lord, that will be
We will remove it.
removed.
If it is in.
Section.
They have admitted that they have not the permissions. No, I have not admitted that.
Please give a copy to Mr. Dey. Mr. Dey, please take instructions. When? Tomorrow? Over telephone, you can take instructions.
My lord, no, my lord, he is, give me the copy. After that, my lord, I can. My lord, he is not giving.
Can you not give it? Give a copy to
I
me?
can give my learned friend in 30 minutes, my lord.
30 minutes.
Yes. I
Give
can
it
assure
tomorrow.
you.
Please take it.
Tomorrow, my lord. As because day after tomorrow, I can.
Why?
My lord, 4:30, before 4:30, my lord,
Within
I can
30 minutes, he will be giving you.
give, my lord, but I must go to my chamber, and after that, all the action will be taken.
Day after.
My lord, your lordship can pass the order. As
My lord,
because he is not taking the permission as yet.
No, my lord, they are saying, my lord, tube
Well,
well.
we can-
That is not the tube well, my
You
lord.
take instructions, let them come. The learned advocate, the petitioner. The calendar din. Yes. Yes.
Lordship, I think so. I'm for the petition, Lordship.
Yes.
I'm Lordship, from Union of India.
Yes.
Lordship, in this matter, Lordship, firstly, I beg to pardon, Lordship, that affidavit of service is not affirmed, but it has been ready. If your Lordship takes up the
Who is the
affidavit of
answering respondent?
National Highway, my lord. National Highway
Appears
Authority,
for the National Highway.
as well as the district magistrate is also the necessary respondent, Lordship, to
Have you served upon the state and the National Highways?
Lordship. I have already served. Service has
None
effected,
of
Lordship.
your none is appearing for the state.
The response from the district magistrate is highly required, Lordship, as he is the
Who appears for the National Highway? You are
competent
appearing
authority.
for
Union of India, not National Highway, my lord.
Union of India is
No.
neither here nor there.
No.
Who appears for the National Highway?
No.
Yes. What have you paid for? What do you want?
My grievances is that, Lordship, in respect of the land acquisition for the widening of the National Highway Authority, Lordship, the entire procedure for providing compensation was not as per law, Lordship, as
Where is the
because
order dated? Where is the order dated? 2nd of January 2024.
2nd of January.
You have challenged that. You have paid for setting aside that. Where is that order?
Lordship, it is page 38, Lordship, letter of compensation, Lordship. Page 38. As because Lordship, this is a communication letter indicating the rate of compensation. But till date, the petitioner have not get the award, Lordship. As per your Lordship knows very well, Lordship, better than me that
Copy of the award has not been served upon you.
no, Lordship. Till date, it has not been served.
DG1. My lord, according to the provision, my lord, there is a provision of Article 5, arbitration, Article 5. There is a notice. there is a
But
provision.
Mr. Dey, unless the award is served upon them,
No, there is no provision of award. As there is, that is a DG1.
National Highways, there is a provision for award.
No,
What are you
that is
saying?
second-
The National Highways Act, National Highways
second
Act.
item, my lord. That is the first item, DG1. That is the compensation by the authority, by the competent.
No, it's an, please see, it's only a notice.
See the-
Yes.
And if your Lordship kindly consider page 35 and previous
DG1 passed by the competent.
You have a copy of the National Highways Act. ওই ফই কিচ্ছু নেই, কি ব্যাপার?
He can file an application for arbitration. Not my lord here. High Court has not any jurisdiction. That is
if
the
your
first.
Lordship kindly consider page 35, on previous occasion, this Honorable Court has already passed order in respect of another matter, Lordship, on a similarly circumstances. Where my Lord Justice Ashish Chakraborty has already directed the DM to deem over the entire proceeding.
My lord, what is challenged by lord, you will actually see that. DG1.
So there is a difference. Here is award serial number. So an award has been passed.
That is the competence. That is my lord. He can file this application. So now arbitration against this my lord.
Unless an award is passed. So there is two things. 1 and 2. After that, if you kindly come to subsection 5, if the amount determined by the competent authority under subsection 1 or 2 is not acceptable to either of the parties, the amount shall on an application by either of the parties be determined by the arbitrator to be appointed by the central government.
Yes, sir.
And subject to the provisions of the Arbitration and Conciliation Act shall apply to every arbitration under this Act. So this is an award passed, not only a compensation. Compensation may be, it's under 3G1. When there is a dispute, so an award is to be passed. As it appears from page 38, it's an award which has been communicated, not the award which has been, copy of the award has not been served.
That is the my lord, if you will see.
Serve him a copy, I will relegate him to section 34. That's a different thing altogether. But where is the copy of the award?
Not 34th after that. 6.
After arbitration.
After
That is why I am saying. After arbitration is the award. It appears it's an award has been passed. It appears so.
My lord, this is not, he is not arbitration.
Yes, that is why I am saying.
My lord, he is
যোগ্য কর্তৃপক্ষ. That's the yes, that is why. Who appears for the National Highway? Mr. Dev, who is the learned advocate who usually appears for National Highway?
Monica Rai. Monica Rai. Every name. He loved the appear.
Uh,
My lord, it is my duty. The state duty. My lord, Bhumikara has not any acting. My lord, that is the state function. That is the competent authority is our officer.
Yes,
But that is my lord state. He challenged the state.
yes, yes. But the national highway authorities have to be present. So, do you have instructions? Because are you appearing in this matter?
No, my lord, I am not.
That is why.
Only
So I'm
my lord.
directing him to serve a copy upon you. Please take instructions on the, because it appears that an award has been passed. If you say no award has been passed, only the compensation amount has been determined, please take instructions on that. Then I can pass orders. But if an award is passed,
No,
a
my lord.
copy of the award has to be served because limitations starts to run from that date.
That is, my lord, that is the we passed the order 3T1 that is in the form. Your lordship, I
But
can-
it says award serial number. Have you seen page 38? It's award serial number.
My lord, then I can.
Please take instructions. The learned advocate appearing for the petitioner has challenged the order dated because his prayer is also that to undertake a de novo arbitral proceedings. So his pleading also says it's an arbitration award which has been. কি বললাম? For the petitioner submits that the petitioner has prayed for setting aside the order dated 2nd of January 2024 passed in an LA proceedings with a further direction upon the authorities to undertake de novo arbitral proceedings in compliance with the statutory mandate. Full stop. Affidavit of, have you prepared the affidavit of service?
Lordship, it has prepared. If your Lordship kindly allow me 30 minutes, Lordship, I will kindly.
Respondents have been served. I record your submission.
Lordship, Lordship.
Learned advocate appearing for the petitioner submits that the respondents have been duly served. First up, he prays for leave to file the affidavit of service in course of this day. First up, such leave is granted. Paragraph, in spite of service, none appears for the respondents. Paragraph, Mr. De, learned additional government pleader, who usually represents the state, is present to appointment regularized. The learned advocate on record of the petition is directed to serve a copy of this writ petition upon Mr. De, upon the junior of Mr. De in course of this day. When? Wednesday? Order. Wednesday next. Orders Wednesday. এই বইগুলো আনাতে বলেছেন? Act 2 of 48 এগুলো সব আনিয়ে। Yes, Mr. Pan.
This is a proceeding initiated under the Act 2 of 1948.
I anticipated this. That is why I asked my officers to bring Act 2 of 1948. At this point of time, Mr. Pan, Act 2 of 1948 has been converted to Land Acquisition Act. Thereafter, Land Acquisition Act 1 repealed, 2013 Act, almost 12 years passed. After the coming into force of the 2013 Act, what remains in this petition?
Up to 1997.
Use the mic.
Up to 1997.
Mr. De appearing for the state.
Yes, hardly any scope for approach to the court because it's a continuing cause of action. So they were under the responsibility to initiate a proceeding convert this proceeding under the Act 1 of 1894. Because since the property was acquired by publication notification.
Who is in possession?
Is in possession.
Possession taken over.
Possession taken over by
When?
invoking 1976. Possession acquired.
Since 1976, Mr. Pan, you are sitting tight.
I cannot because kindly don't misunderstand me. But this is not the responsibility of mine to approach the court every time for payment of compensation. The duty casted upon the collector to pay the compensation. That's why language is allowed. The collector shall. This is a duty because and there is also a provision for interest. Until and unless the payment of compensation, I am entitled to have the interest along with the rate of compensation. So this is not the statute that I have to approach to the court. The land user has to approach to the court. But statute says otherwise, my lord, that the collector shall pass an award and shall make an payment of compensation. So kindly allow me to read the language of the statute.
Yes, what do you want?
No, my lord,
Here, what have you prayed for?
Here I am prayed for, my lord, to determine since they have utilized this land, so pay the compensation
Under the 2013 Act.
And your lordship dealt with this, my lord, in the other cases also, and wherever directed the authority to.
Their stand will be direct purchase policy.
Yes.
Their stand will be direct purchase policy.
Direct policy. But possibly
He's saying yes.
Kindly see, possibly that is not recognized by the law, because policy cannot override the statute. Policy is, my lord, if I go through the policy carefully, my lord, then your lordship will find wherein they are not in possession and for the purpose of establishment of certain things, and there must be an offer and subsequent to the acceptance.
You are not agreeable.
No, my lord, I am not saying so. I am not agreeable. But
That is why,
but
Mr. Pan, in
So-
some
so
matters,
yes,
subsequently,
you
that is why I'm asking you if he is agreeable and Mr. Day's client is also agreeable to
let them file an affidavit to that effect that they will purchase this directly, or
My lord, that is only he filed one. That is the last page 28. Only, my lord, your lordship will see this last page 28. Only, my lord, that is the acquisition.
So what more I can submit?
Whether we can
which is
say
your
them
plot? Which is your plot?
46. That is, my lord.
My lord, that is your
28.
kindly see.
Page 28 is the
Page-
notification. Which plot is yours?
46. That is description of land, the right of side, middle.
46.
Description of land. Your lordship will find description of land. Right hand side.
Right hand side, yes.
And in the middle, my lord, division of
46, yes.
46.
So
That
this is acquired in full.
full.
And where is the document that you are the owner of this?
Yes.
Or you have a right over this
Yes.
property?
My lord, kindly turn to my lord the page 17, 19 onwards. 20, page 46. My lord, page 20, left hand side 46.
46.
Yes. I have described, then my lord.
From
page
whom?
20
From whom you are claiming
Yes.
title?
My lord, first, my lord, I came claiming title, but I have described in my lord that paragraph 2 onward.
From
Paragraph
whom?
2.
From the record of rights.
Yes.
Tell me from whom you are claiming title.
Yes. Onumali Patra, no?
What is your
Page. সেটা কোথায়? সেটা কোথায়?
name? 21.
Yes.
Yes.
Gangawala Patro. Your lordship will find another button.
Gangawala Patro. You are
Yes.
claiming from Gangawala Patro.
Gangawala Patro and my lord, my father, Gangal Patro.
No, who is Gangawala Patro?
My lord, the grandmother. I have stated in.
So
paragraph
from the
2.
grandmother, you have your father got that property.
Yes.
Have you described that?
Yes,
how-
paragraph 2. Paragraph 2. I have categorically described everything. Paragraph 2, paragraph 3. And paragraph 4.
Because these facts are to be verified, Mr. Pan. Because
As and
that's,
when,
that's
I tell you, lordship, as and when they are going to, either they will give me the award or purchase, there is a scope for verification of my titles. I am not standing on that way. Whenever, if
Sir,
suppose
they-
the
what is
award
your-
is declared,
My,
what
my
is your
lord, he can
instruction?
file an application, and that application will be considered by the authority. If the authority never pass any award, or anything else, my lord, then we can.
Sir, they filing affidavits will delay.
No
So
filing.
you have
I do not want to file affidavit. I pray my lord before your lordship. He can file an application before the authority. And
Sir,
authority
you
will
can take instructions. This is the notification. Pursuant to this notification, some LA case
My
has
lord,
been
now I
initiated.
think-
What's the stage of
My lord,
that LA
my
case?
lord-
If you have passed an award, award will disclose the name of the awardees.
Yes, my lord. That,
So
but today,
that
my
will
lord,
be the end
as
of the
because-
matter.
But my
Filing a
lord,
representation,
but
consideration, you will pass one
but
order.
we are now handicapped. Where the state advocate is now handicapped.
Why?
As because my lord, there is SIR and all the officers is taken by the by the commission.
Mr. Dey, this will continue till May.
Only for this reason, my lord.
Mr. Dey,
I pray, my lord. I pray.
don't take this plea because
No, my lord,
then he will start taking adjournment
No, my lord.
from November till May.
I am taking this plea, my lord, as I am going to face this, my lord, difficulties on different cases only for that is
Representation also cannot be considered. He will be saying all will be
by
on
the- by
duty.
the- my lord-
Please file a report as to with regard to the allegations, what has been done, whether this 46 has been acquired, possession, and what is the whether any award has been passed or not. Ashun, the petition
This is my application. Dear my lord, in the two phases,
Our state.
land was acquired. Now, my lord, compensation.
Mr. Pan, you have got that bounded, those acts which you have given last time when I was taking up hearing
That
matters.
is led up to your lordship.
You have not taken back.
No. That is what is in court number 7.
Court number 7 এ উনি একটা bounded সব land being change হয়ে যাওয়ার পর rented out so that it could have been returned. ওটা দেখে নিন
That
No, this please take it back. ওইটাকে আনিয়ে Yes.
the two phases. The possession was taken over by way of acquisition under Act 2 and Malay award was declared. Now what happened, my lord? Subsequently, my lord, I sought for my lord, the conversion and conversion order was passed. But
conversion order was passed.
Yes. Well, that order was passed, my lord. That is that page. The lordship will find on and from
Conversion of the balance portion.
Balance portion. The portion. But that is on and from page 32. Page 32.
Yes.
Then, my lord, I drew the attention of the authority for demarcation of the land and with a sketch map, which is mandatory for the purpose of, my lord, so that I can develop the property. So I drew the attention, my lord, to make a physical verification and draw up a sketch map so that it can be identified which portion is.
Where is the provision for this
Yes,
demarcation?
demarcation provision. I tell you,
Who is for the state?
I am for the state. Section 9. Act 2 te to.
It was under Act 2.
Yes.
I think section 3 or 4 something.
Yes. Now, my lord, section 4.
3 or 4. I
Yes.
think.
Yes. আমাকে দিয়ে দে প্যারাগ্রাফ সেকশন 4 তো জশবকে দিন Yes, my lord. But why I am saying the Act 2, এটা জশবকে দিন না my lord, kindly turn to section 9 of the Act 2 first. Section 9 of the Act 2 which prescribe, my lord, the collector will act under subsection 2 of section 4. Section 9 of Act 2.
Yes.
Authorize the collector.
Where is the Act 2 is not here.
Yes, the back portion.
Oh, yes.
Yes. And can you turn to section 9? Lordship has got it. Section 9.
Yes.
The state government may, with a view to requisition any land or the purpose of determining by the determination by the collector of the amount of compensation payable under this act by order, require any person. Next, C. Authorize any person to perform in respect of any land all or any of the functions referred to in subsection 2 of section 4
Yes.
of the land. Then, manner also can you turn to subsection 2 of section 4.
To enter survey, take levels in any locality
and
to
measure.
Set out the boundaries of the land.
Yes, set out the boundaries.
To be taken and is intended. And the intended line of the work, if any, proposed to be made thereon. To mark such levels, boundaries and line by placing marks and cutting trenches, and otherwise survey cannot be completed. Yes.
So this can be identified. So the rest portion which is not part of the otherwise, my lord, whenever I will apply for the sanction, they will say where is the.
You have applied for this demarcation.
Yes,
where is that?
Yes. And that is that page, my lord. 51. That is that page. 51. Annex 35.
Who is to do this?
Collector.
Collector has to do through the block land and land reforms officer, because
the act provides under the collector. He may take the, because I cannot.
Collector is to be directed, but he is to take the help of the block land and land reforms officers, the amends and other things.
Yes.
Page 51,
Page 51.
because the collector do not have the expertise to.
Yes, yes, he may take, but direction may be given upon the
Has
collector
to
only.
be upon the.
But with the assistance of the whatever the officers they may have. I have detailed. I have said lot in the paragraph page 52.
Yes, what is your instruction?
Not say disciplinary instruction, but the representative can be considered by the respondent of 3, my lord. The special land acquisition officer is the one.
Cannot be done. Access collector, sir.
Actually, it's not a special land acquisition officer, my lord. But
So
collector is the special land acquisition officer. my
Huh?
lord. Collector, here, my lord, the land has been acquired, my lord. Can you see? But on the instance of the, my lord, the land acquisition officer. He is the, my lord, competent authority. my lord.
under the act, please consult the act, sir. Who is the authority under the act? You have a copy of the statute.
My lord, direct, my lord, collector is the authority, my lord.
So collector is to be directed. He is to get it done through the. Ashun.
My lord, this is to place on record in the first, that such and such, then I have described. Then in connection with the construction of Eastern Metro bypass, in paragraph 2.
Yes, 0.5 out of 4.53.
Yes, and 0.1, my lord, 0.75.
Yes, then
Then, my lord,
0.05.
0.05. This is the total area they have acquired.
Yes.
Then, my lord, I stated that 4C conversion order was passed in my favor.
All right. Ashun. of the land. Mr. Order. So Special Land Acquisition Officer
get a sketch map of that from the authority. A copy of it may be handed over to me, madam.
No, I could not follow.
But a copy of the sketch map may be handed over to me.
I've said.
But
Immediately after that sketch map to be handed. বলেছি না? পড়ুন তো ওই জায়গাটা।
obliged. No,
মনে করে বইটা নিয়ে নিচ্ছ না?
জজ সাহেব বলেছেন তো আমাকে।
He's making sure to take back the book.
No, he had handed over a very beneficial compilation of all the statutes, but yes.
I am for the petitioner. The petitioner's land was acquired under Act 1 of
You appear
1890.
for the petitioners also, Mr. Banerjee.
In many matters, my lord. I can appear.
Yes.
My lord, land was acquired under Act 1. 2011 acquisition started, but could not be completed, my lord, before 1/1/2014. So award was declared under Act 1, but the calculation was made as per, my lord, Act 30. Act 30. Award declared, payment made in 2016. Now, some of the awardees of the same acquisition process, it's one LR plot, one section for notification. Some of the, my lord, awardees challenged, my lord, the award given by the collector before the civil court. It was enhanced to some extent. Initially, it was 1,48,000, enhanced by the civil court, the land acquisition judge, which was again, my lord, challenged by the state and the aggrieved awardee, my lord, before this honorable court. This honorable court has further enhanced it to a quantum of 5,32,000 and odd, and fixed the amount at 5,32,000. Now that.
No, that's the valuation per
kata.
Per kata. Yes.
So now, my lord, section 28.
They have to recalculate.
No, I am, my lord, one of the awardee who is not, my lord, the applicant in those land acquisition proceeding. But under section 28 capital A, within 3 months of the verdict of the court, I can apply for same benefit.
For?
Same benefit of enhancement of the award.
28 capital A.
I have made the application within 3 months. That is
the in the new act.
No, new act, it is section 73. Old act. Old act 28 capital A. Since not it was started under old act, I am relying on old act only. 28 capital A. Where in an award, under this part, the court allows to the applicant any amount of compensation in excess of the amount awarded by the collector under section 11. Persons interested in all the other land covered by the same notification under section 4, subsection 1, and who are also aggrieved by the award of the collector may, notwithstanding that they had not made an application to the collector under section 18, by written application to the collector within 3 months from the date of the award of the court, require that the amount of compensation payable to them may be redetermined on the basis of the amount of compensation. This is the first part. Collector will recalculate. If then he is aggrieved with the recalculation, he can
conduct an inquiry.
My lord.
Award pronounced.
Opportunity of being heard. He will pass a fresh award. If I am aggrieved, I can again go to the civil court for enhancement of that amount. But the collector now has not the verdict of the court, so he will have to comply and follow that.
After the verdict of the court, there is no further scope of enhancement.
No, as per the verdict, it has to be
as per the verdict.
As per the verdict.
Now, so in your case, only that rate has to be applied. There is no scope of further challenge.
No. There cannot
because the rate, once the court has determined, you cannot say I want.
No. I cannot say that. I
have made a representation.
Made an application.
In the instant case, my lord, pursuant to the honorable.
Let him finish.
Now, my lord, in this case, what happened, my lord, the court has fixed, the Honorable High Court has fixed, my lord, the amount per kata. And so far as the interest part is concerned, it has left remanded the matter back to the civil court, to the LA judge for calculation of the interest which is payable. But the amount has been fixed. So amount has been enhanced as per section 28 capital A. So I am getting asking
Show
for
me
the
that
same
portion of the judgment very.
My lord. Kindly comes to my lord, paragraph 63
Paragraph
63 at page 78. So kindly come to page 62, my lords. 62, page 77.
Yes.
Accordingly, FAT 516 of 2019 and FAT 3 are allowed in part, thereby setting aside the judgment and impugned decree dated September 20, 2018, passed by the Honorable Additional District Judge Hooghly in Land Acquisition Miscellaneous Case number 7 of 2016, remanding the matter to the referral court for adjudication on the points given herein below. The next page, my lord. The compensation of the acquired land of the claimant is fixed at rupees 5,50,544 per kata.
Yes.
The amount is enhanced. Then, solatium of 100% of the compensation amount as stipulated in section 30 shall be calculated by the referral court on the basis of the above compensation and awarded to the claimant. Referral court shall also award interest at the rate of 12% per annum on the market value as mentioned above in terms of section 3, subsection 3 of section 30. Referral court shall grant an opportunity to both sides to adduce evidence if they so choose on the limited question of the date of possession and as to whether the parameters of section 72 and 80.
Now, Mr. Banerjee, everything has to be done by the referral court, not the collector.
Calculations to be done, but the quantum has been fixed. If your lordship kindly goes back to section.
So it's not the collector cannot do now anything.
No, collector, my lord. The 28 capital A, my lord, I can approach the collector if, my lord, the court enhances the amount. Where in an award under this part, the court allows to the applicant any amount of compensation in excess of the amount awarded by the collector.
Yes.
So excess has been awarded.
Yes.
The first 3 lines, my lord, if any excess amount is awarded, I can approach the collector for under 28.
Yes.
Here, my lord, excess amount has been awarded 5,52,544 by the court. And the other parameters are to be, my lord, calculated. Court has not done the calculation himself.
No, court will not do the
will not do that. The my lord, LA judge will do that. So it has been sent back. Only, my lord, section 80 interest, my lord, your lordship knows from the date of possession till the date of payment, section 80 gives interest. 9% for the first year, then 15% for the rest of the period. For that, court has said that you can adduce evidence when possession was taken. So that this can be.
That has to be before the
learned land acquisition judge. This interest part.
So that is with regard to that matter.
Only interest.
Now, with regard to your matter, that portion, nothing is pending before the LA judge.
No.
He cannot expand the scope of that reference.
No, he cannot.
Whether the LA judge can decide or grant this interest and compensation to persons who did not approach the referral court at that point of time.
Now, my lord, in my humble submission, it can be done by the collector also because it says.
So it has to be done, I think, by the collector because it cannot be by the referral court.
No.
Because it was in that matter, the court directed the referral court because it has remanded upon fixing. So in that case, there was no question of going back to the collector. No. So it's the referral court who will only decide that amount of compensation.
In this case, it has to be collector.
So in this case,
it has to be collector. That is my application. I have made the application before the collector only.
Yes, where is that?
Kindly comes to my application at page 45.
And that is within time.
Within 3 months.
There is no dispute. What happened to this representation?
This is pending, my lord.
So yes, Mr. Bandhavadhyay.
In the instant case, my lord, the award has been passed in terms of the Honorable Court's order in Act 13, not in the old Act. He is, my lord, referring the 28 of the old Act, where, my lord, the compensation has been made under section 11.
No, but Mr. Banerjee,
but how it is
only one thing.
How it is applicable in this case, my lord? When the award has been passed in Act 13, there is no provision of Act 28.
Section 24, if you kindly come to section 20, where is the new act?
It is in that.
It's here.
It's part of that book, my lord. No, but award was under the old act, calculation as per the new.
Yes, that is why I am saying.
Section 24.
Mr. Bandhavadhyay, please take section 24. Notwithstanding anything, you have a copy of the new act.
I have given.
Here is. Yes, my lord.
A 24 1A.
1A, where
1A.
no award under section 11 of the Land Acquisition Act has been made, then all provisions of this act relating to determination of compensation shall apply. So it's only the determination which is to be made under 2013 Act. And B says where an award under section 11 has been made, then such proceedings shall continue under the proceedings under the provisions of the Land Acquisition Act as if the said act has not been repealed. So if it's
Award
this
was not
case is governed under 24(1)(a).
1A.
So all proceedings of this act relating to only determination of the compensation that will apply. So only with regard to that. But it's will be an award passed under the Act 1. Cannot be an award passed under
New Act
2013.
also has a similar
These are
provision,
the
perimeter.
past year.
No. Only compensation determination, only that.
Then they let it be considered by the collector.
Take a decision on this. Mr. Banerjee, where do I get the facts of your case?
But page 44 is my application.
Yes, which
there-
paragraph? Show me that with regard to this, when it was acquired, which
My
notification?
lord. No, paragraph 3 onward, not at the fact of acquisition, my lord. Paragraph 3, then, my lord.
It was initiated under Act 1.
Act 1.
Yes.
Possession taken, but
Possession was taken not much prior. There's a checkered history. Possession was with them. It was requisitioned under Defense of India Act 1950. Much prior. Then they did not return the land. It continued with them. After litigation, my lord, we got an order from the Honorable Division Bench that they have to return the land. In contempt, they
Then
came and said that we shall acquire. So possession continued under them.
so it was notification under section 4 was issued on September 20, 2011.
My lord, September 2020. Paragraph 5. Paragraph 5, page 4.
What is the plot in question?
Plot number is not plot number 2, LR plot number 2804.
Which paragraph? Oh, yes, first paragraph.
First paragraph.
Where is the notification? Have you annexed the notification?
No, my lord, but in the judgment, my lord, your lordship will get the plot number possible. I'll just check up and.
So this plot, along with others, other plots
No,
of the subject
only one
matter?
plot. Only one plot. 2804. It was a large plot of land. Initially, there were several CS plots.
Only one plot was involved in
One
that
LR
acquisition.
plot.
Our other awardees challenged.
They have challenged.
Petitioner
Judgment
claims to be the
Grateful, man.
Coming after 5
Bye.
years.
My lord, I am for the petitioner, my lord. May I pray for an adjournment, my lord, as the landed advocate of record, my lord, hasn't served the copy, my lord. My lord, kindly take it on next week, my lord.
You have not served.
No, my lord.
The learned advocate appearing for the petitioner submits that
I am for the state respondents.
My lord, I am for the petitioner and its service. My lord, the subject land is Rayati land matter, purchased by the petitioner way back in the year 1973, my lord. Her name was duly recorded in RS record of rights as well as, my lord, LR record of rights. Now, what has happened, my lord? Now the state authority is trying to utilize the petitioner's land, my lord, without taking any steps in order to initiate any acquisition proceeding, my lord, without paying any compensation, my lord. My lord, that is my case, my lord. And one representation.
yes, what is your instruction?
My lord, I have no instructions, my lord. Kindly, my lord, come to the page 26, my lord.
Yes.
He stated, my lord, after found that the said plot was not acquired by the concerned authorities.
Yes.
He himself admitted and given representation.
Yes.
He is not sure, my lord, the concerned authorities has acquired or not.
What is your instruction?
My lord, yes, I'll take instructions. My lord.
So I'm directing you to consider this representation.
Yes, my lord.
The petitioner claims to be the owner of plot number of a Next.
Item number
In this
8,
matter, I am appearing for state
just
respondent.
now
my
I have been, in item number 8, my lord, just now I have been appointed to appear on behalf of respondent number 6, my lord.
Yes, yes. Yes, who is for the petitioner?
For the
petition. Yes, what is this matter?
I am paying for some time because I need my lord,
This is a matter.
Uparatnama and also in written instruction. my lord.
And in this matter, private respondent should be added, my lord.
Private, so what is the dispute? Yes, who's for the petitioner?
I am for the petitioner. But
Yes.
the land is under the, my lord, under the airport authority. Airport authority has been already made a party. My lord, probably my.
My lord,
What
the
is the
claim,
dispute?
yes.
What is the dispute is that, my lord, my predecessor in interest is the recorded owner. He has purchased, my lord. I have given the purchase.
Actually, I will-
After that, my lord, he has recorded his name. My lord, now, my lord, these lands has
What
been.
is the
my
plot
lord-
of land?
My lord.
What is the plot of land?
My lord, suit plot of land, my lord, that is 93 decimal, that is
Plot number,
443,
plot number.
443 and 447.
It was acquired.
No, my lord, part. My lord, kindly see the answer at page 28.
Page 28.
Yes. My lord, I have given a typed copy. Though it's my lord.
No, please come to page 32.
Yes, my lord.
Page 32, answer point number B.
Yes.
So it has
This
been
is-
acquired.
This is my
Acquired
lord,
compensation has also been computed.
Yes, 371 my lord, decimal of land. Acquisition is only, my lord, 1.1
Yes.
11.
What is your grievance?
My lord, my grievance is my part has not been acquired. My lord, the acquisition check has been given to somebody, my lord, who has been, my lord, the co-sharer of the property. My lord, 371, I have got 185 and half. And another person, my lord, has got 185 and half. The acquired for the acquired portion, my lord, 111, my lord, will find from page 28.
Page 28, yes.
Page 28. The reply to the RTI. My lord, plot number, my lord, first one, plot number 443 and 447, area 1.11 acres. The
Yes.
total land is, my lord, 3.71 acres. And now they have acquired only 1.11 acres. That too, my lord, they have given the check to this Reverend Gross Prefect of my lord. They have got the amount. And 185 and half decimal, which belongs to me, my lord, has not been acquired. Because there is a specific query, my lord. After that, my lord, I have made, my lord, will kindly comes to page 30. Page 30, paragraph C. This is a query, my lord. I have quoted that earlier reply and stated, my lord, whether, whereas the total plot of that is 2 point. So I need further information as to whether acquisition for the second time has been awarded or not. The reply, my lord, will kindly see from page 32. That is C, no. There is no
Yes,
second.
So only one acquisition was there.
Only one acquisition was there.
Yes.
And for that, my lord, a co-sharer has been paid the amount. My name does not reflect from that.
Your case is also that your portion has not been acquired.
Yes.
So how are you entitled to compensation then?
No, I am not entitled to. I have prayed for release. My lord, can you see? What is my prayer?
So what
Page number
will be
70.
released? What will be released? If it has not been acquired, where is the question of
My lord,
release?
they have, my lord, kept a boundary and, my lord, taken the possession of that land.
Where have you stated
My lord,
that they have put the boundary on the entire plot?
entire plot.
Where have you stated that? Show me.
My lord, kindly sees.
Which paragraph?
বলেছি এটা হতেই পারে My lord, kindly sees paragraph 13. 13. Page 7. my lord, 8 top.
Page 8.
Top. But in fact, it is found that the entire share belonging to the petitioner has been amalgamated with plot number 6, and the same is shown land belonging to
Show me the
airport
record of rights.
Airport Authority.
Where is that?
My lord, that 601, my lord, I have.
Or P7. What is P7? That's the memo. You have said that the entire plot has been amalgamated and shown to be belonging to Airport Authority. Annexure P7 is which page?
My lord, P7 is page 32.
32.
32. That is a reply, my lord.
Yes, but here nothing has been said. From here, how do you say that it has been amalgamated? Both the plots have been amalgamated in the name of the Airport Authority. How do you say that?
My lord, because, my lord, they have stated that there is no, my lord, no plot 443 and 447. My lord, kindly see, according to the statement, the land was acquired from plot number 443 and 447 at Mouja, Jhaljalia, jail number 73. ALA case number such and such, and some
yes, so
proceeding
they have
was
said that this was acquired from such and such person, and this is the amount of compensation. They have not stated anything more.
No.
How do you come to the conclusion that the entire property has been taken over, has been in the name of the
that has been, my lord, we have made, my lord, we have found from it physically. My lord, we cannot enter into
that is your statement, sir, Mr. Dhol. Show me your statement in the writ petition.
That is there, my lord.
Where? You have said that they have put a boundary wall. Where have you said that these properties, these two plots, a boundary wall has been enclosed?
No, boundary wall, my lord. Boundary wall I have not stated.
So the entire property has been recorded in the name of the Airport Authority. Where have you stated? Show me the document. Nothing is there.
My lord,
vague writ petition, Mr. Dole.
My lord, kindly, my lord, allow me to place that 601, my lord, porcha. May I, my lord, plate the 601, my lord, LR plot number 601 porcha.
LR plot number 443 and 447.
That is RS.
Yes.
That is RS.
So the corresponding LR is 601.
601.
You have not made any averment with regard to that.
Yes, my lord, that has been stated, my lord, what I have just shown before your lordship.
Where is the LR porcha? Show me.
My lord, that porcha I have not annexed.
Mr.
My
Dole,
lord,
you have made a statement with regard to that without any documentary evidence to support that.
My lord, kindly.
What is the basis of your writ petition? There is no basic foundation in the writ petition.
Let me place it by supplementary affidavit. Only the my lord 601 porcha.
Yes, who is for the Airport Authority?
I am for interpreting. Just now
Who is for the state?
I am for the state, my lord.
Yes, what is your instruction?
My lord, there is no instruction, but as far I came with this writ petition, I gone through it, and I found that the submission they made in this writ petitions that acquisition authority made wrongfully acquired the portion of petitioner's land instead of the portion of the airport authority's
What
land.
is your instruction?
My
Whether
lord,
you have
now
acquired
we have to
the
take.
You have acquired the portion,
But
and whether you have physically
this is
demarcated
recorded. We have acquired. We have acquired, but that has
entire
been
or a portion.
portion, my lord.
Have you demarcated that acquired portion?
That I have to take the instruction, my lord. That demarcation has been made correctly or not, my lord. Kindly give me some time. I will.
My lord, may I file a supplementary if I get the 601 portion number? Difficult.
Then if you want to file the 601 Porcha, Mr. Dole, you have to give them a copy in advance with regard to that. Please bring the Porcha, don't file any supplementary affidavit, let me see. Their instruction. Mr. Dole, if you file a supplementary affidavit, they have to take instructions on that. If you want that, I can give you liberty to file supplementary affidavit, then a longer time is to be given to them to take instructions on that also. That's your choice.
Because my lord has asked for the 601 porcha. It is, my lord, probably, my lord, I should have annexed.
Bring that 601 Porcha, then I will consider, because they are the custodian of all documents, they know what is there. Yes, next. Yes, Mr. Banerjee.
I have a 4 katha land in Salt Lake which has been leased out to me for.
You have only 4 kathas land, Mr. Banerjee.
That's why I need to reduce.
Yes. Yes.
Calcutta land in Salt Lake leased out to me for 999 years by the government. I wanted to, but it was leased out for the purpose of building a residential building. There was this clause that within 3 years from the date of the demise, it's 999 years.
Clause within
3 years from the date of the demise,
you have to construct
a building. Now the clause is within 3 years from the date of the demise or within such further time as may be extended by
so there's a provision for extension.
Yes.
You have applied for the extension.
I had applied for the extension. This is
what happened to that prayer for
once in 1996 I had applied. It's a 84 lease. In 96 I had applied for extension. Extension had been given for a year. Then subsequently I could not make the construction at that point of time.
The extended time.
Yes, there are various circumstances why it couldn't be done. Bona fide circumstances, including illness. There was an illness in the family. There was a death in the family. These are things that are on record.
So now, from 84
yes,
to
I can understand.
2025.
I can understand.
So it shows you don't need that.
No, I need it, my lord. I need it badly.
From
so
84 till 2025,
yeah,
you have not constructed that.
Yes. Now, my lord, what happened is suddenly I found, my lord, in the year
which is the authority.
Now in the writ, now, my lord, no, the things have happened. This is second round. We came up before this honorable court when the authority concerned showed a board saying that this is now Shorkari land, government land. We came up before this honorable court. The authority concerned said that we have already forfeited the lease. That was the stand there. However, in the lease deed, there's a condition that there has to be a 6 months prior notice for remedy of the breach. That notice, the authority could not show service of. Therefore, this honorable court, my lord, by the first, in the first writ petition, please come to page 114. 2nd January 2025. This is my 2019 writ petition which came up for consideration. Court has, my lord, considered everything. The ratio is at the reasons, my lord, are at.
So your representations were directed to be considered.
Yes. Representations directed.
And the board was directed to be removed.
Yes. The board has not yet been removed. That is one of my grievances here. Another
that remedy lies elsewhere.
Writ for implementation of the writs, but then that board is really secondary.
Contrary judgments are also there, Mr. Banerjee.
One of Justice Jayanto Bishwas that I can remember.
Following Supreme Court.
Yes, it has to be executed.
Supreme Court is a binding precedent.
It has to be executed.
Yes.
They say it has to be executed.
Yes.
So, but then we still have a few Supreme Court, Justice Shubhra Kamal also.
So there are two conflicting
leaving my lord free to grant remedy to relief to me because they cancel each other out. As of now, the law is not settled. Now, but I'm not removing the board is just an ancillary thing. Even if the board is not there, but actually the actual effect is, what they are saying they will resume. They will resume according to them.
No. What happened after the consideration?
They heard us. They passed an order. In that order,
that is under challenge now.
They spurned
what is the decision they have taken?
They spurned my request for extension and they rejected it. Rejected my request for extension. And then, my lord, kindly see.
The detailed grounds have been given.
But no ground has been given. That is, thankfully, my lord, the order of rejection and Mohinder Singh Gill helps me a bit. Page 175, with your lordship sees, it falls back on that notice of alleged breach of lease, remedy of the breach, which he has never actually served on me. He says it's in 2007, we have remedied the breach, we have served you a notice, despite the notice you have not.
Show me the demise, original.
Yes, please have page 37 is the original lease. The testatum is at.
Show me those relevant clauses.
Yes. Please come first to the testatum. That's at page 23. Testatum is a clear grant. Sorry, page 38. Internal page 23. Page 38, my lord.
38.
Yes, 38, my lord.
No, show me that clause of renewal clause.
Yes. 6A, page 39.
6A. And where is that provision of re-entry? Power to
Yes,
re-enter.
that's given 43. Come to page 43 kindly. Clause 4. Clause 4, page 43, internal page 7.
So according to you, this 6 months notice was not
served.
given.
And that's a finding of the court during the first round of litigation. That has now become res judicata. They have, my lord, in their reasoned decision by the department, sought to, in effect, sit over that finding and say that we have given you a notice, we have given you a notice. Now, that they have not given a notice, ওই জায়গাটা চলে আয়। Please come to page 118. That's the first round.
No, please show me the reasoned order.
Yes, yes. Please come to the reasoned order first. 174. Yeah, 25th of March 2025, third paragraph, my lord kindly sees, has not construed the clause as a whole. He only sees within 3 years. But the clause was or within such extended time. Therefore, the clause provided for extension. Now, my lord, last paragraph of the first page. This peremptory final notice, 10th of September 2007,
yes,
was not served. And that's a finding of the court in the earlier round. Please come to page 118. Yes. There's a finding of the court. Property Act.
Show me the letter of extension.
The first letter of extension.
So there were 2 extensions.
1996, 1 year, 2007. Yes.
Show me the last extension.
Yes. 2007. It's not there. Oh. The last one is not on record. I'll bring it. I'll have to show your lordship. I can understand from there. I can understand why your lordship is wanting that. I'll have to bring that.
Banerjee, that is the
I'll have to bring that. I'll have
cause
to
of action of
yes,
your...
yes, yes, I have to bring
That is only the cause of action.
No,
that's
I'll
the
have to
cause of action.
I'll have to
That's
bring
the,
that. I thought it was on
that's
record.
the only
Yes, yes,
document
yes. Which is relevant.
Which is relevant.
Yes.
For
show me
consideration
the earlier
Earlier
letter of extension.
1996.
Dekho. অ্যানেক্স করনি আগের রিটটা আগের to come back.
Both the 96 and 2007 are absent.
Now these extensions were granted is not under A, but
Letter is dated 10th of September 2007.
according to them.
Mr. Banerjee, I can assist you better. Page 107.
কি রে? না সেটা notice they say that they have served on us, but they've actually not served. 107. Here there is a finding.
107 not served.
No.
That's a finding. How did you get a copy of this?
Annexed to their affidavit in opposition.
Where?
In the earlier writ. And the court returned a finding.
Supplementary affidavit is
Page 98, that's a supplementary affidavit that the state filed. In that, affidavit of Mr. Rajiv Mondol, in that, my lord, 107 is an annexure. They say that they have served, but there's a finding of the first court, of the coordinate bench in the earlier.
What is page 102, Mr. Banerjee?
102 is
that same letter with the name that they have served. That's 107 is the typed copy.
I think is the typed copy of 102 is a handwritten come cyclostyle copy. 107, my lord, I think is the typed copy.
No, this is not the letter of termination.
It's not a letter of
Please read this letter.
Yes.
You can
Whereas
read it
plot
from
number
107. That's the clear version.
107 clearer version.
Yes.
Whereas plot number 186, such and such Bidhannagar was leased out to Mr. Jiban Das Bajaj by the Governor of State of West Bengal by a registered lease deed executed in his favor on 28th of March 1984, inter alia with a specific condition laid down in clause 26A of the lease deed that the lessee shall construct the building on the demised land within 3 years from the date of possession of the demised land or such extended time as may be allowed by the government in writing. And whereas possession was delivered to him on 24th of May 1985, and whereas it reveals from an inquiry that the plot is still lying vacant. Now, therefore, the Governor of the State of West Bengal is pleased to serve upon him a notice under clause 4 of the aforesaid indenture to remedy the breach caused by violation of clause 26 of the lease deed within 6 months from the date of issue of this notice, and if he fails and neglects to remedy the aforesaid breach by getting his building plan sanctioned by the competent authority and by starting the construction on the demised land within the stipulated period, the aforesaid lease granted by the government shall stand determined, and the government will re-enter into possession of the aforesaid land or in part thereof in the name of the whole after expiry of
You also say there were 2 extensions.
No,
that is
my
the
lord, this
pleading
is
with regard to the second extension.
Yes.
Show
Now,
me.
second extension. না এরা এখানে বলছে দুটো extension আছে দেখ. From where I have got it. Please come to the page 174, the first page of the order.
174. Yes. No, in the writ petition, have you pleaded anything with regard to the second extension?
No. Writ petition, my lord, we say that there has been one extension.
So your case is that there is only one extension,
One
not 2
extension.
extensions.
Yes, that is our case.
Show me that pleading.
Yes, please. এখানে pleading নেই। নেই না? আগের রিটটা extension এ pleading নেই। There is no pleading of extension I find, my lord, in the writ, but there is a recording of an extension granted in 1996 for 1 year and in 2007 for 6 months.
Writ petition pleadings are very important, Mr. Banerjee. You have to make out your case on the pleadings.
I understand that. I didn't have opportunity to go through these before it was filed.
Because
I know, I can understand that.
This is the basic pleading.
May I come back with a supplementary affidavit? May I come back with a
Yes, Mr. Mahato, what is this?
My lord,
This should be dismissed, my lord. He may be given opportunity to file if there is better case. He can substantiate that. No, 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 no.
No, I think the one
After-
supplementary
after-
can do, one supplement, I'm not changing the cause of
After
action.
Bharat Kumar judgment without pleading and specific prayer, no writ can be
There is a
allowed.
specific prayer. I am not hinging too much on that extension because of the fact that subsequently there has also been a judicial order accepted by the parties.
Show me that finding in the earlier round with regard to this extension.
Please come to 118.
118. Yes. Show me only that relevant part.
Now, was served. Please come to 118 in order to examine the aforesaid issue. My lord has found that, my lord. 118.
118, yes.
Yes.
Which paragraph?
In order to examine the aforesaid issue.
Yes.
Kindly skips that clause. Clause 4 is quoted. Upon cursory reading of the aforesaid clause, it is manifest that the lessor shall not exercise the right to re-enter into possession of the demised land without serving upon the lessee a notice in writing giving 6 months' time to remedy the breach. The state respondents, though, have contended in paragraph 3H of the affidavit in opposition that the notice was issued to the petitioner on 10th September 2007. This is the notice, alleged notice of remedy, invoking clause 4 of the lease deed, but there is no specific assertion that such notice was served upon the petitioner. On 10th of April 2024, liberty was granted to state respondents to file supplementary affidavit in order to clarify the situation as to whether notice under clause 4 of the lease deed was served upon him prior to re-entering into the possession of the demised plot. In compliance thereof, the state respondents filed supplementary affidavit annexing the notice dated 10 September 2007 for determination of the lease and re-entry into possession. However, it is relevant to note that no such postal receipt showing issuance of such notice has been appended therein. Further, there is no document, namely track consignment report or acknowledgement due card of the postal department produced to show that the notice was duly served upon the petitioner. It has been averred in para 3.1 of the affidavit in opposition that the peremptory file and notice was also sent to the Director of Information West Bengal INCA department for causing publication in daily newspaper. Mr. Mukherjee, learned advocate for the petitioner, has rightly pointed out that in the event the service of notice as per clause 4 was complete, there was no occasion to cause service by way of paper publication. It is pertinent to note that no such paper publication has been annexed to the affidavit in opposition or to the supplementary affidavit. In the light of the above, it construes that the requirement as per clause 4 for the lessor to serve notice in writing to the lessee, giving him time of 6 months to remedy the breach prior to exercise of right of re-entry into possession, has not been duly complied with by the state respondents. This court finds substance in the submission of Mr. Mukherjee, learned advocate for the petitioner, relying on Sanjeev Bhagat Supra, that no order of cancellation of lease can be passed without giving the lessee a reasonable opportunity of being heard. Kobita Shaha has been set aside in appeal, and therefore, my lord, finally, the direction land manager Bidhan Nagar directed to consider. In view of the above discussion,
Where is your finding for rejecting the representations of 2016 and 2019?
My lord,
what is the reasons for which you have rejected the representations of 2016 and 2019?
my lord, the reasons are twofold. One is, my lord, that if you notice the concluding paragraph, it has already been given last chance for 6 months in the year 2007 and in 1996.
Where is that, Mr. Mahato, that could not serve? You could not produce in the earlier round of litigation that in 2007 you have served them an advance notice. If that you have not served, you cannot again fall back on that 2007 notice.
Is the remedy, but the relating to the extension of time, there is no dispute. The breach the remedy 6 month time, my lord, that could not be produced.
Yes. So if you could not produce, so you could re-enter after giving them 6 months notice. So if you have not given them 6 months notice, you could not re-enter. So on that, with that finding, you are directed to consider their representations of 2016 and 2019. So what is the independent reasons assigned by you apart from that September 2007 notice? You could not have fallback on that 2007 September notice as a ground for rejection. No independent reasons.
My lord, kindly consider that the lease was executed in 1984. Possession was handed over in 1985.
Because
1985,
this order is binding upon you. You cannot travel beyond that order. You cannot again, when it has been in the earlier order, it has been found that you failed to produce, that notice was served upon them. So if that was not done, so you cannot again fall back on September 2007 notice and cancel that. That's the only reason for which then, since two chances were given, there was no two chance, only one chance. So it's a perverse finding of the authority.
And two chance, my lord, there is no dispute about the 2007 chance.
Show me that two chance. Where is
My
the
lord,
second chance given?
my lord,
Second chance was given by that notice. Show me where is the second chance given.
yeah, my lord, then my lord, kindly fix on Friday, my lord, I will bring that 2007. If there is no second chance was given, then my lord.
Mr. Mahato, please kindly come to that notice.
Notice I have seen. Notice
So,
is not. Notice is
in
not.
the earlier round, your contention was that we had served them a notice of 10th of September 2007. That cannot be a ground. It has been
Section 4. That is to breach remedy.
Yes.
That is not extension.
Yes.
My lord, if my lord kindly give me time, my lord, so that I can produce the second. In 2007, there was the opportunity was given for extension. Only that point.
Till Monday?
No,
Or let him assure you, Lordship.
nothing will happen.
Let him assure you, Lordship, but till Monday.
Mr. Banerjee, you are holding on the property since 1985.
85.
Till now, nothing has been done. I think you can.
He's still showing if they in the meantime, sometimes it happens that taking advantage of the fact that there is no interim order, they change the circumstance.
But without any interim order for this long.
Yes, but since
The order was passed in 25th of March 2025.
And
No explanation for this delay.
should not
From
no, that's there.
not be
That's there.
transferred
No,
to
no,
third party.
they forwarded it later. It's a March order. They have forwarded it late. That explanation is given.
Yes, so for this you are without any interim order, Mr. Banerjee. That
Yes,
is what
that's
I'm
all right.
saying.
No, only thing
From
is
March, you could hold on to the property without any interim
what
order
sometimes
till
happens with
November.
the state. What sometimes happens with the state is once
will-
my lord has taken up the matter and made it returnable without an interim order, they take step
I
in the
think
meantime.
nothing will happen, Mr. Banerjee. Yes. All the next matter. Yes.
I'm for state, my lord, led by Mrs. Shabnam Devartha.
Yes.
This is, my lord, the prayer for consideration of the representation for payment.
What is the issue in the representation?
For compensation. Lord, the things for a moment. I draw Lord's attention paragraph 2 and
79 acquisition proceedings. Why are you coming now?
yes, ma'am. That
Why?
kindly appreciate the original owners died. The petitioners before lordships, the subsequent, my lord, the legal years.
Yes, what is your instruction, madam? What
I
happened?
have taken my lord.
Please use the microphone.
I have to take instruction, my lord, kindly.
When you are served with a copy,
accommodation.
madam. When you are served with a copy. When the copy was served upon you, why did you not take instruction?
Got the whip, my lord. Today morning I got the
Today
whip,
morning.
my lord.
When have you served?
This is served long back.
Long back. So if you have got the copy today, that cannot be a ground.
The things for a moment, some of the payment has been
I
done.
have
Some payment has
communicated,
not been done.
my lord,
Drawing Lord's attention.
but not
page
received
59.
the report.
Earlier occasion, my lord, the owners, some of the owners come before this court, the order has been passed on a consideration disposal. On that basis, some payment has been done, some payment has not been done. That's my representation by the legal years of persons that have not yet been considered and disposed of. Let the authority be decided this matter.
What is the plot of land?
That is paragraph 2 I have stated.
Paragraphs?
Paragraph 2. In the mass my lord, the plots of land taken.
You are the owner of all the plots.
No, we are the legal heirs of the owners of the plots.
Yes. So you claim to be the owners of all the plots.
But this is joint property.
98 writ petitioners.
Yes, madam. This is the
all are claiming through one owner.
Oh, no, not owner. Remember the 3-4 owners. Some of the owners of payment has been done. Some of the owners have not been done. That has been claimed difficulties. All are the land losers. They have land already taken back. Taken.
The petitioner Yes, Mr. Ghosh.
Blood ample.
General, my lord, why the penalty can come for the appearing on behalf of the state, my lord?
My lord, I am for the state.
Oh, I'm state.
Yes.
The petitioner is the owner of Lord 22 decimals of land. It was purchased in 1959 by the father when petitioner was a minor. Lord, in the deed itself, it has been indicated that out of 50 decimals, Lord, except the road and Nayanjuli, the actual owner has sold 22 decimals of land. Accordingly, 22 decimals of land was recorded in his name. And it continued, Lord, till 2019. And Lord, thereafter, all on a sudden, 6 decimals of land has been recorded in the name of Public Works Department under a separate Bata Dag number. Lord, as yet, several petitions were filed. There was directions, but the authority concerned has never, Lord, surveyed the 531 Dag number. Simply that Bata plot has been measured and it has been held that it is the land of the PWD, and Lord, he has been directed to remove his structure from the said Dag number.
Are you challenging any order?
Yes.
Where is that decision?
Lord, last page, Lord, that is at page. This is the order. Lord, at page 106.
106.
8/9/2025. It starts. Lord, not 100.
Which is the relevant order?
P21, Lord.
109. Order dated 15th of June 2022.
Yes. No.
8/9/2025, my lord, suppose.
Page.
Lord, just give me.
P21 to work.
Lord, 116.
115.
115, my lord. This is the order.
Okay. 116. Relative 115. And this is based on Lord the BLRO's report. And
please give me a minute.
Yes, my lord.
Rights
Blood
of the plot number 531.
Blood, your lordship kindly come.
Show me the RS record of rights.
RS record of rights. Blood, your lordship kindly take first the deed. There, what I have purchased. Blood, your lordship kindly come to page 29.
29.
Yes. Lord, 29 last paragraph. Tag number 531 531 দাগে 50 ডেসিমাল মধ্যে রাস্তা ও নয়ঞ্জলি বাদে 22 ডেসিমাল
Page 29. It's
Last
not
paragraph.
legible, Mr.
Last
Ghosh,
paragraph.
and it has been stitched upside down. All right, 29A, a typed copy has been given.
No, 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 that has not been. No, it is not. 29A, yes.
29A, a typed copy has been given. But from where are you reading that?
No, no, your lordship kindly come to page 20. I'm reading, Lord, for your lordship. Lord, last portion 531 531 নম্বর দাগে 50 ডেসিমাল মধ্যে রাস্তা ও নয়নজুলি বাদে 22 ডেসিমাল।
Where do I do not find that? Where is that? Because the page is not legible.
Then kindly Lord, see my copy. Lord, last paragraph kindly see. Totally illegible, my lord. Nothing. কোথায় পড়া যাচ্ছে এটা?
531 নম্বর দাগে
এরকম
Yes,
হয়?
Mr. Ghosh, your copy is legible, but my copy is not legible and it has been stitched upside down.
No, it's not. Sorry, my lord, I'll do it. But kindly see, read it.
All right. So 531. Show me the record of rights. RF
Yes,
record
I'm
of
saying.
rights. 531.
I'm screen. Now, Lord, your lordship, can you see the record of rights? Lord, your lordship, kindly come to page 34. That is my predecessor's record of right. Paragraph page 34, 531. Bhava Vibhuti.
550 decibels.
50 decimals. Next.
And it was recorded in the name of, who was your predecessor?
Bhava Vibhuti and others.
What is the name?
Bhava Vibhuti.
Oh, Bhavo Vibhuti, yes.
Now, Lord, kindly come to page. He was the erstwhile owner, my lord,
Yes,
of
yes.
the set. Page 35 more.
Page 35.
Aniruddha Hajra 22 decimal. So 22 decimal out of 22 decimal, 6 decimal, because Lord, in the meantime, he sold 16 decimals, 88 to two other persons. Lord,
so this is 531 is 6 decibels.
6 decimals. Now, Lord, there was no
Bata. Aniruddha Hajra.
Yes, Aniruddha Hajra is the petitioner. Lord, now kindly see.
So in Aniruddha, so he has purchased 6 decimals.
No, he purchased not 22 decimal, 22 decimals.
No.
Lord, your lordship will get it. Lord, next I'm showing.
22 is the entire. He purchased 6 decimals. দাগের মধ্যে অর্থ শর্তের জমির পরিমাণ is 6 decibels.
Yes, Lord,
so Aniruddha purchased 6 decibels.
6 decibels.
Out of 2022. Out of 22.
Lord, kindly see. Total 22 decimals. Your lordship will get from the other. Yes, page 39.
Page 39, yes.
Aniruddha 6. Out of 22 decimals, 531, the total, that 22 decimals. Lord,
yes, Aniruddha is 6. That is what I am saying.
Lord,
Aniruddha is 6.
Lord, this Swapan Kumar, Orghasis, Chandan Kumar, their transfer is from me. 8 decimals. Total 22 decimals.
Total 22.
Total 22 decimal I purchased. Lord, thereafter I sold 8 decimal, 16 decimals to.
Oh, you purchased 22.
Yes. Thereafter
and you have transferred by way of several deeds.
That is admitted.
So now you have left with 6 decimals.
6 decimals. That right. 6 decimals, Lord, in 2019 only. This is 59. 2019 only, Lord. All on a sudden, they made a Bata plot, and it has been recorded as. Lord, kindly take the text up. Lord, your lordship, kindly see. This is page 40. Development Road. Aniruddha is not there. This is a separate Bata plot, 531 by 823.
Yes. How this Khotian was created?
That has not been explained by the dealer also.
How this Khotian was created?
But I come back with the report, my lord, from the concerned authority. The police has given the report, my lord, but this report is not given.
Cannot say anything because this is the record of rights. As it appears up to 14th of March 2019. That is, there is only one dag, that is 531. And this 531 by 1 was created by in Khotian number 558. Show me how it was created by virtue of that Khotian.
Allow me a week time, Millard. I'll come back, Millard, with the proper instruction. Millard, because this entire thing has been done, Millard, as I read out from the Millard writ petition, that entire thing has been done by upon field inspection.
Sir, field inspection.
I can understand.
Thing.
My lord, I can understand what is
the
it.
Rayati property.
My lord.
Now, how can you take over a portion of that Rayati property and record it in the name of a development board?
My lord.
How this Khotian was created, that is to be looked into.
My lord.
What's the basis of that Khotian? Because this 531 was 22 decibels up to March of 2019. So by what process this development board came into picture, and where is the Moja map? Where is that Moja map? This will show the extent of the entire Dag number.
Enter that number. Keep it in the next week, Millard. I shall come back with the proper instruction.
Lord, only one Lord BLLRO has been added as party as respondent number 6, but his name has been typed during time limited. We have sent him by reading the name. Kindly correct this. His serial is number vacant.
Serial number is vacant.
After 5, 7 has been typed. 6 has been
Sir, Ghosh, is it not a dispute with regard to correction of a record of
not
right?
correction, Lord. They have acquired, directed to remove from highway authority. Highway, kindly see the direction.
No, is your instruction? It has been acquired.
My
no instruction.
Asking you.
Yes.
No instruction received, Millard, as yet in respect to this.
Acquisition, if you say all right, but then you have to show how you have acquired and you have paid compensation. Acquisition, you have a right to acquire.
My lord.
But without acquisition, you cannot record your name of a development board in respect of a property in question.
My lord. I shall come back with the instruction, Millard. Give me 1 week time, Millard. Meanwhile, I'll.
The petitioner alleges
I'm for the petitioner, my lord.
Yes.
I am for the state respondent.
My lord, this is a matter relating to illegal encroachment over National Highway Road.
Yes.
My ingress and egress have been restrained at the instance of the respondents, particularly by the councillors. I am the recorded owner of the property. I have been using the property for a long time, but despite of that, they have encroached into my property. All my belongings have been stolen. My go down come
Who have
shop room.
encroached?
The encroachers are the local rowdies being blessed by the local councillors. I have approached before the councillor for assistance. It turned to the deaf ear of the councillor. They did not turn up. And my lord, in the meantime, as I moved an application under section 144 CRPC, at that point of time, the date for report had been called, but after filing of that particular 144 application, they did not turn up. My lord, I have annexed the documents pertaining to record of rights, along with the photographs and everything, my lord, to show that I've been in possession of that particular property. After raising my voice, the concerned municipality has cut down my water supply to cause maximum prejudice, my lord. This has been the situation under which I am living.
Where is the representation?
My representation, the petitioner's representation on page 23. And so far as the advocate's representation is on 26, my lord.
Oh, this is the FIR. This is the inaction on the part of the police authorities.
My lord,
this is বেআইনি প্রাচীর ভাঙার এবং FIR এর জন্য আবেদন পত্র.
My lord.
So this is for registration of an FIR that cannot be granted in this jurisdiction.
26, my lord, National Highway. Since the ingress and ingress.
Show me that. That is right. Page 26.
Yes, your lordship.
Yes, Mr. Dev, what do you say?
Considered by the authority, that is National Highway Authority, my lord. That is.
You are representing the National Highway?
No, my lord, that person.
He was here, my lord.
Where is he?
To here. Yes, my lord. They have just said that we will be back. We will appear in this matter.
Where is he? Who is the learned advocate? What is his name?
Name to jane na. Mary and Company is the authority, my lord. Mary and Company on behalf of. পালিয়ে যায়নি মানে খাচ্ছে বড় কোম্পানির ছিল তো
তো সাত আবার কি
খাচ্ছে আমার পাশের ঘরে বসে এসো কি হচ্ছে এবার থেকে একটু তাড়াতাড়ি এসো মাইলট খুব তাড়াতাড়ি বসে
Yes, my lord, I appear for National Highway Authority, my lord. Respondent number 4, my lord.
Yes.
My lord, he will consider that.
Consider this representation.
Very well, my lord.
Which authority?
That is respondent number 4, my lord.
My lord, respondent number 4 over here is Chief General Manager. So, the respective authority would not be the Chief General Manager, Chairperson. It would be the project director. He is not implemented.
Project director.
It should be the project
director, National Highways Authority.
Yes, ma'am.
What is the address?
Same address.
Same address. It would be the same address.
Same address as the respondent number 4.
As 4.
All right. Please implead the project director.
I'm
on the prayer of the learned advocate for the petitioner. Leave is granted to the learned advocate on record of the petitioner to implead the project director, National Highways Authority of India, as a party respondent in this writ petition. Let such amendment be carried out. Let such amendment of the cost title of the writ petition be carried out here and now. When carried out per comma, here and now, full stop.
Project director.
Since the National Highway Authority is
My lord, I'm praying for not today, my lord. I'm for the petitioner.
Please start. Don't pray for not today. Yes. What is this matter?
My lord, item
What is
My
this
lord, I
matter?
have not
I
advocated
am
record.
appealing the private respondent.
You are not the advocate on record. This is the chance to move. Yes.
Lord, I am private respondent, my lord.
Right,
My
advocate.
lord, this petition, my lord, is not at all maintainable, my lord, and my lord, this prayer, kindly see.
Yes, my lord, but as he,
Advocate on record business.
my lord, I
Appellate side.
kindly, my lord. I have no brief also.
You are not briefed. Who will brief you?
My lord,
Who will brief you? Yes, who is for the state?
Mr. Mandal is appearing for the state, but he's
Mr.
in another court, your lordship. He's in another court. He's on like.
Yes, what is
Lord,
your
I am for private respondent.
Right now, I
my
don't
lord.
have any instruction. If your lordship give me 1 week, I'll arrange for one.
My lord, this is absolutely, my lord, civil, my lord, dispute with regard to Patta, my lord. Kindly cease the prayer, my lord. This petition is not maintainable, my lord, in this forum, my lord. They have separate remedies, my lord.
Yes, madam. How this writ petition is maintainable? Prayer to grant patta.
my lord, kindly.
Who is the competent authority to grant patta? Under which provision of the act? Yes, where is your senior?
He was ill, my lord. He was not. No.
All right. An accommodation has been sought for on the ground of the learned advocate for the petitioner. To stop the hearing of the writ petition stands adjourned. Yes, next.
Grateful, my lord.
My lord, I am appearing on behalf of the petitioner.
এটা দিয়ে দিচ্ছি, তার এটা রেখে দিন। আচ্ছা, ওইটা পেয়েছেন? ওটা কোথায় এনেছেন? Yes, who is for the petitioner?
For the
Yes.
state. I am for the petitioner. My lord, petitioner are permanently resident under ward number 10 of Bolpur municipality. On 8 July 2024, respondent number 3 comes with a JCB and demolish their boundary.
Who has demolished?
Respondent number 3. Bolpur municipality. Bolpur municipality. That
My
demolished.
lord, I am appearing on behalf of the petitioner, my lord. May I interject, my lord? I am appearing on behalf of the petitioner, my lord. He is my junior, my lord. My lord, the crux of the matter is that on 8th of July, my lord, the respondent number 3 came with the JCB and broke down my boundary wall. Now, my lord, they are saying that it's an illegal construction. My lord, I am the only person, we are saying that if it is an illegal construction, my lord, they could break it down. We have no objection to that. But we are residing here for more than 35 years. We haven't been served with any of the notices that the boundary wall which is being
for the Bolpur municipality.
none of them are appearing, my lord. We have filed, we have the affidavit of service, my lord, we can file that. We have served them
You are
also.
challenging an action of the municipality. So does it come within group 1?
My lord, the municipality has, my lord, the municipality has done this act on the words of PWD. This is the thing which they have stated.
From where they are getting that, I don't know. There's no notice, they say.
But there is no notice, but they have verbally stated that we are coming from the PWD offices and we have been instructed by the municipality authorities.
No,
yes, by the municipality. So it's an action of the municipality. How does it come within group 1, sir? It's an action, overaction, whatever you might say, it's of the municipality. It's a group 5 matter.
Then
How
my
come
lord,
this is a group 1 matter?
and may I take the indulgence of my lord my lord to release this matter, my lord. My lord, we can make appropriate actions.
The petitioner is aggrieved by the action of the municipality in demolishing the boundary wall of the property, the boundary wall encircling the property of the petitioner. Full stop. When it was faced with such situation, the learned advocate appearing for the petitioner submits that liberty be given to the petitioner to amend the presentation form and to approach the bench having determination. Full stop. After going through the averments made in the writ petition, it appears that the allegation is against an action of the municipality. Full stop. The issue involved in the writ petition is a Group 5 matter. Full stop. The learned advocate on record of the petitioner is granted liberty to amend the presentation form. Full stop. The matter stands released from the list of this bench for want of determination. Full stop. Petitioner will be at liberty to approach the appropriate forum, to approach the appropriate bench having determination over Group 5 matter.
Grateful, my lord.
Yes, next.
Lordship, I am appearing on behalf of the petitioner. This is my affidavit of service.
Yes.
There are 7 private respondents. I have served upon this, but these are all returned as not known. Now,
returned as
not known.
Not known is not a good service, sir.
But the only the
not known is not a good service.
But the matter is regarding unauthorized constructions over the national highway. The petitioners are the absolute.
Where is the national highway? There are different advocates.
But I have served upon the
National highway have been served. Sir, please appear. Yes.
The petitioners are the absolute owners of the land, which is.
So private respondents have made an illegal construction.
Yes, private respondents constructed the unauthorized constructions, and as a result, this is one of the obstructions in front of my land. You
are the owner of which plot?
I have kindly comes to the para 1. Yes. I am the absolute owner and occupier in respect of the land.
Para 1.
Para 4. Para 4. Para 4.
Elad Dag number 2078.
Elad 2078. Khotian number 3720. 3721.
So they have erected some shop rooms, buildings. In front of your property.
In front of my property, and I have averted. This is
so thereby obstructing the national highway 117.
117.
Yes. What is the representation made?
Representation.
To which authority?
I have made the assistant engineer, Diamond Harbour National Highway Subdivision, PWD Roads Department, along with other respondents. Kindly come to page 29.
Page 29, yes.
This is my representations. And the same was forwarded to other respondents concerned.
Yes.
My lord, we have to see whether the land belongs to the National Highway Authority, my lord.
Consider that if it does not belong
my
to
lord,
you,
this representation is not even issued to us.
Lordship,
this is PWD, the state National Highway, my lord. This is PWD, Project Works Department. This is not the National Highway.
No, Lordship, I have
not the Central Highway, my lord. Not
a central highway.
Not the National Highway. This is the state highway, my lord. There are 2 separate highways.
Yes, notice has been given to Omyojana is the private respondent.
Omyojana is. Bacho, Omula Das, Vikram. No, Omyojana.
Please see, kindly come to page 24.
24. 24 is one of the notice which was earlier issued by the assistant.
Omyojana is not party.
Here, Omyojana is not the party. We have served our representations upon the respondent number 8, and after.
Yes, sir. Bandopadhyay, what do you say?
Well, the national highway now belongs to the state. State is looking after this case, my lord.
So you can
Let them
represent.
proceed in accordance with the National Highways Act.
Lordship, after receiving the representation,
Did not appear. All right.
My lord.
Under the control of West Bengal Nationalized Land and
kindly
Traffic Act.
see,
Go to the
Lordship, after receiving my representation, they have issued this letter. Kindly see.
I shall take my lord's leave, my lord.
Yes, yes. Yes, yes, Mr. Bandyopadhyay. Yes, I'm directing the assistant engineer Diamond Harbour National Highway Subdivision to consider this.
To consider the representations.
Because assistant director has also issued a notice for inspection also that he has.
And at the time of inspections, he requested the BLRO should be present.
BLRO has to demarcate that. What is the identification? BLRO is the appropriate authority. The petitioner Yes, who is appearing? None appears for the petitioner at the time of call, no accommodation.
vesting order.
There is no reflection in the LR record of right regarding the vesting. There is no.
Where is the LR record of right? Show me.
Page 49.
Page 49.
48. All are all riot property.
Page 40.
6 to 46, 47, 48, 49. No vesting remark is there. My riot property. A single quotient number 1 is not reflected.
Yes, Mr. They.
How they say it is a vesting property through the RTI reply.
Mr. They, please take instructions. It appears that the information under the RTI
I
Act
also
was not
collect live
correct.
data. From Bangla Bhumi website till date it is not.
Lot number 825.
825 and 826, there are two plots. Where is 825? 825, which page is 825, 826?
Is 25, is 26. Page 8.
826 is
My lord, there is the information is 825.
826 is there. That is at page 51. 51. And where is 825?
Page 20.
Page
20.
20.
20 and 19. 825, 19, page 19. Live data from collect from Bangla Bhumi. And second page 20. Live data collect from Bangla. I am against 2560 Kotian, MD Jamaluddin. And this Kotian second page, my father. Live data, it is not reflected, there is a vesting property.
Yes, it appears from this document.
But
not a
RTI
vested
reply is
property.
contradictory
However,
with
given this
the public display of
information,
Bangla.
please take instructions, because as it appears from the
Or your lordship can ask the BLRO to give him the copy of the same.
it appears it's not vested. Please take instructions.
But
If it is vested,
in RTA, my lord,
RTI, but the record of rights he has annexed. It's also of a recent origin. When it has been vested? The RTI information is of 20. Where is the RTI information date? Is 16th of August 2024. But from the website of November, it says November also, subsequent date. It's recorded in the name of the rats.
But on 16th August 2000.
How can it be? Because subsequently it is named, the names of the record rats is appearing. It's not a vested. Please see page 19 and 20. It's a subsequent document. After the information has been furnished, please take instructions. When?
Barasat 2.
Barasat, it's near. When?
Friday.
When this matter is taken up for hearing, Mr. Dela
service kept.
Every service taken on record. Yes.
My lord, 18 on behalf of the petitioner, my lord. My lord, it relates to the demolition of illegal encroachment, my lord. The petitioner made representation for removal of
filed an
illegal
application.
encroachment, which has not been considered yet, my lord.
Lord, I have filed an application for addition of party. Your lordship kindly consider. Lord, I am necessarily interested party. If your lordship allows me, I'll demonstrate how. Lord,
Unauthorized. I will hear you. Unauthorized encroachment upon
the West Bengal highways land, my lord. State highways.
state highway.
Yes, my lord.
Who has encroached?
My lord, private
Client.
respondent.
no, Lord,
Private respondent.
Lord, that is not correct.
Private
Fact, Lord.
respondent.
He is the intervening party, my lord.
Lord, I am Lord Holdia Hawkers Association, which was granted a sublease by the then Lord Holdia Country and Town Planning Lord Authority, notified authority under the sublease. Now, after obtaining necessary Lord sanctions and other things, Lord Holdia Association Lord allotted the shop rooms. Those shop rooms are Lord have been Lord their petitioners, the private respondents, and others members. All 120 and more than shop owners Lord are running their shops. There is no Lord, the allegation of the respondents that I have Lord encroached. That is Lord, the state authority can very well say there is no encroachment. There is enough ingress and ingress road, and the petitioners Lord, the private respondents, my members have Lord constructed the shop rooms as per the approved plan, and they are not on the petitioner's land at all. Lord,
No. They are not saying on the
on the
petitioner-
road,
the highway,
on the
whether
road
you have
which has been
encroached the highway or not.
yes, my lord, but that is not also correct because the authority, appropriate authority.
Only one thing, my lord. Prayer says government land. Representation says government road. If it is road, my lord, then possibly your lordship is having jurisdiction. If it is government land, then eviction of unauthorized occupants from government land, that will possibly another
No, my
statute.
And the land, my lord, that is
So the prayer is
Road or land?
prayer is land.
Lord, belongs to the road. My lord,
Representation
my
is
lord,
road.
land includes road, my lord. As
and
per
the my lord, the
concerned, my lord.
Now there is a
determination.
determination.
Yes, yes.
No, my lord, it is belongs
And
to public PWD roads.
Roads.
Yes, my lord.
Representation says so.
PWD roads.
Representation
Lord, kindly permit
So,
me.
Once, my
Lord,
lord.
hurry, my lord, the these deed which by which Lord, we were granted the permission to Lord, sanctioning planning is also there.
You are
That-
the association.
Association, yeah, I moved
My lord, kindly see.
association, some of the members, but some other members also there. Lord,
If the association is
Reply-
added, the members.
yes.
So there is no necessity.
Absolutely.
Members also.
Yeah, but
So-
association is not added.
Right.
Association is not added here.
Kindly see.
In this
I'm
institution.
adding the
My
association
lord,
as a party.
my lord.
I give you a right to
Yes,
be represented.
yes.
Uh,
Yes.
Kindly see.
And in the meantime, my lord, the one other writ petition is pending before the municipal jurisdiction because the authority, my lord, I have applied for extension of the lease deed. Your lordship earlier,
that's a different cause
but
of
I will
action.
raise all these points before the authorities.
My lord, one thing, my lord, I am concerned. That is mainly the
Sir, your association is will protect your rights.
Specifically, my lord, we are implemented party. Specifically, we are implemented.
Some members
You have been implemented.
some members, 8 members.
So that protection is required to given by your court, by lordship. That until and unless the decision has been made by the municipality as regards sublease, granting of extension of sublease.
My lord, I moved before your lordship.
Property belongs to the highways.
No.
Municipality also cannot grant-
It is not high. My lord, I moved. My lord,
So
what
let
I
that-
not
if it is not the property does not belong to the highways,
and
then
the
municipality
yes,
does
not at all.
So let
And
that-
your lordship, my lord, I moved the writ petition with your lordship. Your lordship dedicated the matter to the Holdia Development Authority.
Your lordship
They also
is order.
considered. Thereafter, my lord, the matter is pending before the authorities, municipal authorities.
Where is that order? Show me.
Your lordship's order.
Madam,
Your lordship's order is at page, my lord, at page 61.
Sir, allow him to make submissions.
Page
Yes.
61, my lord.
Yes.
Application or written?
Order, my lord's order.
61.
Addition of party application.
Oh, addition of party. We have filed an application.
Yes.
That. Addition of party application.
Can 2 of 2025.
Can to আছে তো এখানে থাকবে না কেন can to
Yes. আপনার কাছে কপি আছে দিন না দর্শক আমার তো একটাই কপি আছে
ওর কাছে আছে
এটা
হ্যাঁ এটা
Should I give my copy? My lord?
মানে কাইন্ডলি টেক তুমি এটা নাও
ঠিক আছে
Your Lordship simply relegated the matter for consideration of the permanent settlement before the Haldia Development Authority. Nothing more than that. My representation was to be considered. Thereafter, the Haldia Development Authority, they say now the authority belongs to municipality because after the abolition of the Country and Town Planning Act, the Haldia municipality has the authority. So I moved the Haldia authority. That representation is pending for consideration. I also filed a writ petition praying for direction of the municipality to consider my representation. That's why, my lord, my rights are to be, my lord, protected. I should need to be heard. Municipality or the development authority,
yes
they cannot grant lease, license or renew
no at
in
that time
respect of a property which belongs to the highway.
yes but that is not belongs to the highway because the at that
The
time
highway is the best person to decide
and
whether that
Milord-
belongs to the highway or
yes
not.
and one thing, Lord, at that time Haldia notified authority had the jurisdiction to not grant
The authority, the highway authority, if it finds the municipality is also to be heard,
yes
they will hear them.
my lord. And I need to be heard. You kindly add me, otherwise we
Yes,
they will
yes,
not.
I'm adding you.
Yes.
I'm allowing this can 2. Can 2 is allowing the is adding only the association.
Association.
Well, I also filed an application for approval.
সেটা তো
So you
can number
said that you have been added as parties.
No, they are the some of the 8 members. They are already party private respondents.
Yes.
They are, but since my all members' rights are to be protected, so
Some of the
members.
some of your members are parties. Why? What is the other application? Can 1?
Can 1, it is my lord, my application. I filed an application for appropriate order.
No, that's
Well,
for
I am-
protection. For
it is
protection, not
relevant.
to
For protection.
protection.
not to-
In the meantime, the BLRO, BLRO,
Your application.
BLRO filed. Just now, BLRO issued a notice for demarcation. I say that demarcation is to be done. There's no, I cannot object the measurement and other things. BLRO filed report. That's they want to restrict. But I, as an officer of the court, I shouldn't say that BLRO should not demarcate. They are not the
Can
authority.
2 of can 2 টা করে দিন আসুন 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 can 2 of
And I am for the petitioner, my lord. So this matter was heard along with item number 49. Today they are appearing separately.
You are shifting the places, Mr. Banerjee, once this side, that side. It's difficult to. Yes.
In this matter, my lord, matter was taken up on 22nd September along with item number 49. Reports are called for.
No order has been passed here. There is no order here.
Lordship will take up the file of this. It is there, my lord. 22nd of September 2025. Both matters were taken up together. Server, my lord.
It was taken up along with
the WPA 1088.
That is item number 49, my lord.
49 এর ফাইলটা বার করুন তো।
আলাদা আলাদা হয়ে গেছে।
Both matters separate reports are called for.
You are the petitioner in both.
Both the matters.
You are the state in both.
No, my lord. Item number 19, I am appearing. 49, my lord, another set of lawyer.
Who will appear? Mr. They will appear then.
No, Mr. Porikshit Goswami, my lord, possibly.
Either you or Mr. They.
No,
Mr. Mahato.
No,
Everybody is here.
No, other set of lawyers there, my lord.
Yes, now what is the issue?
The issue is, my lord, land was.
So reports were directed to be filed.
Yes.
This is Mr. Bandyopadhyay. Why have you not filed this report?
Come with the report.
Copies were
What is the issue?
Issue is, my lord, under Act 2, my lord, section 4.1 and notice was issued. In
Act 241A was issued.
1986. Now, my lord, 1997, the life of the act expired. It was not completed. No award was declared. Now, as per the amendments, my lord, subsequent amendments as declared in Shobita Mondal judgment, if the proceeding lapses, then it cannot be revived under Act 1. In this case, my
So it has to be compensation under 2013 Act.
compensation under the 2013 Act.
Yes, Mr. Bandyopadhyay.
That is not the case, my lord.
Reports. Yes.
My lord, that is not the case before your lordship, my lord. My lord, your lordship kindly turn to paragraph 3.
I have delivered a judgment on this issue.
No, that is not so easy, my lord. He is not submitting this, my lord. The petitioner state that the petitioner.
Which paragraph? Which paragraph?
Paragraph number 3.
Yes.
The petitioner state that the predecessor of the petitioner, namely Sri Binod Kumar Das, was the owner and occupier of property measuring 3.71 acres situated at plot number 913, 915, 916, 944, 963 and 1006. Such and such. Sir Binod Kumar Das mutated such and such, my lord. Therefore, my lord, respondent, paragraph 5, they have stated the possession has been taken, 4.1 notice. But they have not annexed a single document in support of this case, my lord. Which notice was issued, whether for section 4 or possession. I have come with the report, my lord. These lands are not involved in this case number. That is the LA case number, my lord. In paragraph number 5, they have stated 37 of 78, 79. Paragraph number 37, 5, my lord, they have stated.
Paragraph number
5. Page
5,
4.
yes. LA case number 37.
37 of 78, 79. Prayer is, my lord, the same. My dear lordship, kindly.
So according to you, these plots were not the subject matter of that
Yes,
LA
my lord.
case.
There are 4 LA cases. My lord, your lordship, kindly turn to page.
Mr. Bandyopadhyay, only one thing.
My lord,
Were these
it is
plots
clear before your lordship. My lord, page 30, your lordship, kindly turn to page 30. 30 of
30?
the petition.
Yes.
My lord, got it? Before
Yes.
4 cases, my lord, there. 18 of 1881, 57 of 78, 79, 36 of 78, 79, 37 of 78, 80. My lord, their prayer, my lord, this land has been acquired in LA case number 37 of 78, 79. I have come with the report, my lord. This plot of land, plot number, my lord,
Give a copy to Mr. Banerjee. Yes.
Second paragraph, my lord, I am reading. Having scrutinized all the relevant papers of this office, it is found.
So it was not acquired under LA case number 37 of 90.
And not possessed by the government.
It was not acquired.
No.
Next, so I am recording your submission.
That is the possession certificate. Next page. This plot is not, my lord, taken.
So this does not take into consideration Mr. Banerjee's plot of land. No, Mr. Bandyopadhyay, only one thing.
Taken my land, but kindly record
No,
that.
no, no.
Only one thing.
It appears from the report, my lord. I cannot, my lord, alter, my lord.
Mr. Bandyopadhyay, there is two things. Maybe that these plots were not subject matter of LA case number 37. My query to you, whether these plots were ever requisitioned under Act 2 or 40.
That is not, my lord, appears from the report.
Mr. Bandyopadhyay, you are an authority. You are an authority. You must be knowing.
Page 31, their own
Specifying the
letter.
plot number.
Well, it is their allegation. Their land has been acquired.
because
They have not
annexed any
document in support of that case. It is mere allegation. Their lands have been
File a
acquired.
one-line affidavit that this plot
I
is
shall
not
file affidavit.
subject matter of any acquisition proceedings.
Yes,
or
I shall
matter.
file
I will direct them to utilize their property as their Ayati land. Please file a one-line affidavit that these plots were not subject matter of any requisition, any acquisition proceedings.
He should consider.
So I'm recording your submission that these were not subject matter of any.
Record my submission pursuant to the report filed by the district magistrate
Mr.
today.
Bandyopadhyay, it's a way to bypass the actual facts.
No, my lord.
Plot numbers have been mentioned. Maybe
Another case, my lord, that is in my lord. The report has come with me, my lord. That's what my lord. The plot of
you produce all the notifications of these three LA cases.
Yes, my lord. I shall file affidavit.
Lordship,
report, not affidavit.
Kindly see page 31 once. What they have said on getting representation from my father. They say I am.
Yes, I have
They
seen.
say I am to invite reference to the above and request you to endorse another move to higher authority for fund for payment of long-standing outstanding bill. In this connection, I am to forward a letter received from one Sri Binod Kumar Das, who happened to be a land loser related to LA case number 37 of 7879.
Yes.
So that is so. That
What
was
is your,
misled by them. They should
It is from the executive engineer, my lord.
Yes, so they should.
My lord, executive engineer. I have come with the report from the executive engineer. Here, lord, kindly see the report of the executive engineer. My lord, they have no documents. They, as such, they have not forwarded this letter before the land division collector.
Yes, plot number. These are the plot numbers which falls within the acquired area of 3.71.
No, my lord. As per their, my lord, allegation in case number such and such.
Yes.
My lord, your lord, kindly turn over. But the headline, my lord. This is the allegation of the petition case number 180. Therefore, my lord, the assistant executive engineer forwarded this letter to the executive engineer, land acquisition collector for getting information.
No, they are not saying about Act 1.
No.
Lord, what they are saying, kindly allow me to read. What is the instruction?
Mr. Bandyopadhyay, please turn over the next page. Please turn over the next page.
Yes.
Not acquired.
Point number 5. What is your remarks as against point number 5?
Not readily available as these requests.
So how could you then give this report? When the records are not available in your office, how could you say that these plots are not
by the executive engineer to the special land acquisition collector, and it appears from the report filed by today, my lord, by the district magistrate from the LA collector who has acquired the land. The record is lying with the special land acquisition collector's office. That is not the Mahananda.
Yes.
Executive
Let the
engineer.
special land acquisition officer file a report in the form of an affidavit.
Because it says it was not acquired because they could not complete the acquisition.
They have not annexed a document.
Act
Their
one was-
allegation my land has been
I have
acquired.
annexed sufficient documents to make out my
return
case.
my land. That should not be, my lord.
The petitioner alleges
Sufficient documents.
that
But he is coming. He is coming.
He's coming. Yes, in this matter, who is for the respondent?
I am for the state.
সাড়ে তিনটে বাজে আপনি করবে কেন?
করবো না তো।
Yes, Mr. Mahato, what do you want? What both of you want? Want to move? You don't want to move? Please tell it frankly.
তুমি করবে না কিন্তু।
Yes.
His case is that, my lord, in respect of a plot, there is a
encroachment,
but
PWD encroachment by the private respondent. Have you served the private respondent?
I serve, possibly they are not accepting, not address is not found. But pursuant to my law, in response to my application, that assistant engineer forwarded a letter to the BL and LRO.
Mr. Ghosh, the only difficulty is that after 3:30 in their
after
absence.
3:30, all party, if all party is not there,
then two more.
Also, there is a resolution, Milord, if both parties are not present, no matter will be taken up.
Both
From
parties
2
are
PM.
present.
2 PM.
2 PM.
From 2 PM.
You have not told me.
Also, my lord. The bar association has not, my lord. informed.
Nobody has informed. And all matters, both the parties were present.
That
All
is
of them are.
unfortunately.
All right. Now, chalo.
My lord, yes, sir.
Slowly. Item number 49, you are appearing.
Yes, my lord. Yes, my lord.
Yes. What is your instruction?
My lord, report, my lord. Come, my lord.
What is your report?
Kindly take up tomorrow.
24 তারিখে রেখে
Just order দিয়েছেন রিপোর্ট ফাইল
ওটা
করতে
না,
অর্ডারটা দেখে 24 তারিখে
আপনার নামটা রেকর্ড করে দিন। বন্দ্যোপাধ্যায়
ঠিক আছে 24 তারিখে থাকবে 19 তারিখে